Hello, this is Greg Maxwell with Amicus Settlement Planners. Today we're going to cover Medicare Secondary Payer Compliance, and we're going to try to give you a brief bird's eye view of what you need to know in order to comply with the Medicare Secondary Payer Statute. This is something that we could spend an hour on, but we just want to give you the very bare bones so that you know where to go from there. So, just give you an overview. First of all, the Medicare Secondary Payer Statute was enacted in 1980, and it was enacted to make sure that Medicare always acted as a secondary payer to primary insurance. And primary insurance includes third-party liability carriers, UIM carriers, self-insureds, and that kind of thing. So the primary payers are responsible to pay for injury-related expenses. They can't pass the buck to Medicare to pay for those expenses. In some situations, a set-aside is established to create kind of a deductible account that the client can then use before they pull out their Medicare card, and we'll talk a little bit more about that in just a moment. But essentially, the Medicare Secondary Payer Statute says that plaintiff attorneys need to consider and protect Medicare's future interests in a settlement. So we talked briefly about a Medicare Set Aside. There's a lot of confusion about what a Medicare Set Aside is, when it's needed, and that kind of thing. A Medicare Set Aside is essentially a deductible that must be paid before the client pulls out their Medicare card for injury-related Medicare-covered expenses. So for example, if your client is injured and injures their shoulder, and there are certain expenses that are going to be associated with that shoulder injury in the future, before your client can pull out his or her Medicare card for those shoulder injuries that are related to the accident, they need to spend down what's in this Medicare set-aside account. So there's been lots of back and forth recently, in recent years, about the necessity and requirements of an MSA. Is an MSA required? And as of the recording of this video, no, they are not required. The CMS has not issued any guidance on whether an MSA is necessary in liability cases. Some professionals think that it is coming, others don't think it's ever going to happen, but we will let you know if anything ever changes. But as of now, your responsibility is just to consider and protect Medicare's future interests. And so in some situations, a Medicare set-aside may be the best option. Another option to consider and protect Medicare's future interests may simply be just a third-party opinion letter that you can put in your file. So it's essentially an opinion from a law firm that gives you and your client guidance on how to handle Medicare's future interests. It's not as formal as a Medicare set-aside, but again, since Medicare set-asides are not required, it often protects you and protects your clients and gives education and advice without the formality of an MSA. It also protects your firm a little bit in that you have a third-party opinion from another firm helping you and your client know what your duties and obligations are to protect Medicare and the Medicare Trust Fund. Again, this is a complex issue that is going to be very fact-dependent based on your case, based on your client's past medical history, based on the size of the settlement, based on your client's other access to other insurance besides Medicare. So if you have a case where a client is on Medicare or will be eligible for Medicare soon, give us a call and we can talk to you about maybe what the best option is to make sure that you, your client, and your firm is protected and that you've protected Medicare and the Medicare Trust Fund sufficiently.